This is copyright 2, part 1. We are at pages 55 and 56 and 59 through 69 of the textbook. So what do we have in this section? First, we have a preliminary issue, which is discussed at pages 55 and 56, which is substantiality. And then the rest of the section deals with the rights of copyright holders. So substantiality is mentioned in sections 5 and 3 of the Copyright Act, which describes the rights of copyright holders. And these rights exist in relation to the work or, and I quote, any substantial part thereof. And then later on in this section, we're going to look at the various rights of copyright holders, such as the right to produce, reproduce, and perform in public. And all of these rights are actually phrased as the right to perform the work or any substantial part thereof in public, the right to produce or reproduce the work or any substantial part thereof. So substantiality should be understood as essentially a trigger issue. And so copyright is about preventing people from copying your stuff, and it's only going to constitute copying under the law if it's copied enough. If you've copied enough of the work or enough of the substance of the work for it to trigger the application of copyright protection. And so some copying is okay, and substantiality acts as a trigger issue for that. Then we have a case to illustrate that issue, the Montreal Museum of Archaeology case, which we'll affectionately call the MMA case. And in the MMA case, you have a museum that essentially takes a pretty long book, takes essentially a few sentences out of that, a couple hundred words from unrelated parts of the book, and wants to use those in the museum. And then the issue is, does that violate the copyright of the copyright holder, that is the person who owns the copyright in the book? And the court applies this substantiality trigger issue and says no. And the court says essentially 2 or 3 things depending on how broadly you construe them. First, the court says, well, it's from a bunch of separate parts of the book, and so individually the passages are not major copying because they're from different parts. It's not one big passage. Then the court says the various passages are not important parts of the book, right? They're not the crux of the book. And so we have this idea, right, that substantiality exists, not only in quantity, but also in importance. And so it's a holistic approach, but it's a quantitative and qualitative approach. And third, the court says, well, taking these sentences does not jeopardize the legitimate commercial interests of the copyright holders. And so we looked in depth last week at essentially what the purpose of copyright is, and that is to protect economic interests, right, in opposition to moral rights, and to favor the production of various works by incentivizing economically copyright holders to produce work so that they can make money from them afterwards. And the court says, well, from the sentences that the museum takes from the book, they can't really make money with it. It doesn't threaten the ability of the copyright holder to make money with their book. And then we have another case on the same 2 pages on this issue of substantiality, and that is the case of Anne Green Gables. And then we are introduced to another important issue regarding substantiality, and that is that it is possible to steal or copy the substance of a book, right, without literally copying the book. And that's going to be an important nuance, especially considering what I told you last week. Last week we discussed, right, that copyright does not exist in ideas. Copyright exists in a book, right? Not in the underlying ideas of the book. And so if I have a great story idea, someone can steal it under copyright law until I've written it down on a medium, say a book, that is itself copyrightable. Now, that does not necessarily mean that the only way to violate copyright is to copy and paste the physical content of the book. That's an important nuance, right? And so what I could do, right, I could steal the character from a book. Let's say, you know, this is essentially the case in Anne Green Gables. We have a character that is basically the whole point of the book, right? The whole narrative of the book. And then I just, you know, take that character and write my own story. Well, that would violate the rights of the copyright holder. And that seems weird, right? Because it seems like I haven't stolen really the content of the book, which is protected by copyright law, but I've actually stolen the underlying ideas. In that situation, it would still be a violation of copyright, but not for that reason. It would be a violation of copyright because by taking the character from the book, I've taken what is a substantial part of the book. And so we have to make a distinction, which I admit is very hard to make in some situations, between the underlying ideas, which are not protected, and if we take the very general ideas of a book, right, the fact of having, you know, someone drive down a highway, it is so general as to be an idea and it wouldn't be protected. Or the idea of having, you know, people meet in a restaurant. But, right, if I steal a character without stealing verbatim what is in the book, that is not general enough to be an idea, and under the standard of substantiality, it can constitute a substantial part of the work and therefore a violation of copyright. So this is an important, difficult distinction, but it's important to remember that stealing a character is not the same thing as stealing an idea, because it's more specific, it's more important in the book, and it's a substantial part of the book. And the reason that it violates copyright law is not because it's an idea. In fact, it's despite of the fact that it could be construed as an idea. It's because it's specific and important enough to constitute a substantial part of the book, even if it's not verbatim, right, under the standard of substantiality, which, as we said, is a trigger issue to the application of all of the holder's rights under the Copyright Act. And so that's the conclusion from the case. Now, as we move on, the following section, pages 59 to 69, are about the rights of the copyright holder. So, what are these rights? We have an enumeration of the most important one, but this is not exhaustive, right? So, if you look at the Copyright Act, and you probably should, even though you don't have to learn the entire list, it's not important here. If you look at the Copyright Act, there's actually an enumeration of rights that is much, much longer than that. But the main ones are listed in that section, and they're the ones that you should know. So, I've rephrased them a little bit to make them clearer to understand, but I'm going off the same list. So, going back to the conceptual issue of the Copyright Act, right? As we said, copyright is defined at the beginning of the Act. And we have in sections 2 and 3 general descriptions of what copyright is, where it exists, and what rights it confers upon the copyright holder. And that applies to all of the works that are covered by copyright per the two sections and the definitions. And we have some, as the textbook states, some specific descriptions in some contexts, most significantly a performance, a sound recording, or a communication signal. Everything else is covered by sections 2 and 3 of the Act, and for our purposes, it's not really important to look at how the regimes may or may not differ for these various works, because most of the works fall under sections 2 and 3, which enumerate what the works are and what the rights that are conferred upon a copyright holder. Again, it's worth recalling this distinction between economic and moral rights. As we said before, both last week and earlier today, we always have substantiality as a trigger issue. So as I said, the copyright holder has an exclusive right, as we said last week, a commercial monopoly, right? A right to the exclusion of everyone else. And so no one can do it, not just one party they've contracted with, no one, as a result of the commercial monopoly that's granted to them by the government. And they have these 4 main rights, again, non-exhaustive, but all of these rights incorporate substantiality as a trigger issue. And so they have the right to reproduce and perform the work or any substantial part thereof. So the standard always applies. Back to this distinction between economic and moral rights. If you remember last week that I hammered home this idea, right, that copyright protects economic and not moral rights. And generally, that is true. As a general rule, all of the regime that we see today and saw last week is about economic rights, and the distinction is important in the case law in both defining the regime and justifying the regime. However, it's not quite true that there is no protection of moral rights. It's simply that for most of the regime, right, we're only concerned about economic rights and the interpretation and justification of the regime. But, and I'm mentioning this briefly here because we'll see it in much greater detail later on, I kind of lied to you a little bit because moral rights are protected under the Copyright Act, and that is under Section 28. So what's important here is that this is a different regime, right? We've been concerned with the general definition in the early sections of the Act that apply to all works, and moral rights are not relevant there, right? And that's why they're relegated to another regime later on in the Act, and as we'll see, that is not relevant to the principles that we're studying now and for most of the section on copyright, and also that are different, that have different higher standards. But it's worth mentioning them briefly here because they're mentioned in one of the cases that you've read, and that is under Section 28 of the Copyright Act, right? So you'll recall my example from last week, right, of me making a statue. If I make a statue, right, I have an exclusive right to have my statue and make money with it. So someone cannot copy the exact statue that I've made or a substantial part thereof. They can't make a very similar copy, and they can't make a very similar copy of a part of it. And I told you that a good way to illustrate that is to say, what if someone puts toilet paper on my statue? Well, if someone puts toilet paper on my statue, they haven't copied it, right? They haven't mutilated it. They haven't, made a copy that they'll sell to someone. They haven't jeopardized either my commercial monopoly, the number of statutes I have, because I have a monopoly on reproduction as well, and they haven't really jeopardized my ability to enjoy my rights under the regime. But there's something wrong for me as an artist in seeing my statue with toilet paper on it, right? It doesn't convey what I want it to convey. And that is protected, right? But not under the same regime. It's protected later on in the Act under a separate regime that is more restrictive, as I said, under Section 28 of the Act. And essentially, what we have there is a different standard. So, Section 28(2) says, have the right to the integrity of a work, right? So I have the right that my work not be, cut apart or mutilated, because as a general rule, the person who gets my stuff can do whatever they want with it, right? So I have a song, right? I make a song and then I sell it. So I've taken advantage of my commercial monopoly. No one stole it from me, no one copied it from me, right? And to the extent that they did, they paid for that. And so that's absolutely fine under the copyright regime. Once the buyer has the song, they can essentially do, quote unquote, whatever they want with it, simplifying things here. So they can, play it as many times as they want for non-commercial purposes. They can listen to it as many times as they want. They can listen to half of it. They can split it apart and so forth, right? So Section 28 says the artist, in that case, may, in some circumstances, have a right to the integrity of the work. That is a different regime, right? Because copyright is concerned with copying. And so the trigger issue is whether I've copied the whole thing or a substantial part of the whole thing. What we're saying here is different. What we're saying is the artist has a right to the integrity of the work. And so when the buyer has the song, or when the buyer has the statue, they're limited in what they can do afterwards because they have to preserve the integrity of the work. They cannot mutilate my statue. They cannot put toilet paper over it. They cannot take my song, split it apart, put bad words in there, turn it into child, song, put some weird music over it, anything that would jeopardize the integrity of the work. And that is different, right? That's about my dignity. It's about the integrity of the work. It's about my artistic work, right? And saying, well, I haven't just made this to make money, right? I've made this as art to contribute to society. And if people take it apart, right, even if it doesn't cost me anything, right, even if it doesn't, prevent me from, selling more pieces onto the market, it is a violation of the integrity of my work and of my dignity as an artist. And so that is limited. And so the copying, right, could be of the whole thing, a part of it, but then when the copying is done legally, when you've paid the copyright holder for it, then you can do whatever you want with it. What Section 28 does is it says, well, there's an extra right that's different to ensure the integrity of a work. And so you can do whatever you want with it. You cannot challenge its integrity, right? Standard under Section 28(2) goes as follows. The author or performer has a right to the integrity of a work or performance only if, right, the work or performance is, to the prejudice of its authors or performers' honor or reputation, mutilated, distorted, or otherwise modified, right? That's kind of the example we've been giving, or used in association with a product, service, cause, or institution, right? So, someone plays my song in, a store selling stuff that I would rather not have my song playing in. I would be using it in association with a product, service, or cause to the prejudice of my reputation. So what's important here is it's a separate regime, right? So for most of what we're learning now, you don't have to think about that, about the right to integrity, the moral right, because it's a separate regime. It has its own rules. It's different, right? And it's more restrictive. I just read you the standard. So I have a right to the integrity of my work, right? Integrity means, destroying, mutilating, using it in a place that I don't want it used. But the standard is what I read you in between the commas, and that is to the prejudice of the author's or performer's reputation or honor. And so the standard is much higher here, right? Because I don't have a universal right to the integrity of my work. I only have that right if the person that is violating it is prejudicing my honor or reputation. So it's not any infringement of integrity that counts. It's only if it's prejudicial to my honor or reputation. So unlike copyright, which is you cannot copy the thing in whole or substantial part, period. This is you cannot infringe a right of integrity, but only if you do so to the prejudice of my honor or reputation. The standard is different, the regime is different, the standard is higher, right? And, there actually has to be proof of this, right? So if I want to sue someone under 28.2, I'll have to show that my copyrighted work is subject to the right to integrity, and I'll have to show that they've prejudiced my reputation. I'll have to actually, show proof of that to recover money from the person. So that's the distinction between economic and moral rights. But for our purposes here again, we're back to this concept in general that copyright is only concerned with economic rights. So, back to those rights that are granted to the copyright holders. I said not exhaustive. 4 main rights. You'll see here we have reproduce, and so the right to produce or reproduce the work or any substantial part thereof, right? The right to perform in public. This is compounded here, right? The right to perform is exclusively of the copyright holder for the work or any substantial part thereof, but only in public. So it's compound, and as we'll see, the second part is pretty important, at least as much as the first one. And we have the right to publish the work, right? If it has not been published, again, the work or any substantial part thereof. And we'll call this generally, fourth, the right to assign. So the right to authorize someone else to do all of that. So as the copyright holder, I have all these rights, right? But these rights are not personal to me. I'm perfectly allowed, right, to assign them, to assign them to my, say, children, because I want my children to make money with my stuff, or to a company that is gonna be much better than I will be at selling my stuff, or I can license it, right? I can say, well, you sell it and then you give me a royalty. So instead of assigning it forever, I can assign it temporarily, in part, and I can do that with the 3 things, 1 of them, 2 of them, whatever it is. And so this is not really a separate right. I mean, it's really a characteristic of rights more generally. So this is a right that is personal, like most rights. So if I have a right to be paid rent, I can assign that to someone else. I can sell it to someone else, or I can transfer it to someone else. And this is true of rights more generally, whether it's right to a contract, right to compensation. And there are only very limited exceptions where the right cannot be transferred, right? Like I cannot transfer the right in Quebec, say, to the violation of my bodily integrity. I can't sell the right to touch me, right? That would be against public order, as we say, or as normal people say, wrong. But as a general rule, most rights can be assigned, and that's true as well of rights arising under the copyright regime. So, a significant part of this, which you're mentioned specifically in the textbook, is the right to authorization, right? And that arises in technological context when there's more than one party, right? So let's say I have a book, right? I can say, well, it's a really good book. I'll make, $1.5 million with it over my lifetime. But I don't want to wait to have $1.5 million. I want to have $1 million now and then not, manage my book and then go out to the Bahamas and spend that money. I can do that. I can take my book, sell it to a company, they'll give me $1 million, and then they'll have the future rights to collect the money from the book because it's theirs now. They exercise the copyright holder's right. They now are the copyright holders. I no longer am, right? And the company proceeds to do that. Now, in some situations, especially with technology, we have a more complex situation where we don't just have two parties with one party that has the right and then transfers it to another party. Sometimes we have both parties acting simultaneously, right? What if I have a song, right, that I want to sell and then I pay Walmart to play my song in their stores, right? Because I want people to hear it to induce them to buy it. Well, in that case, I haven't really transferred the work. I've either paid Walmart to play my song or Walmart has paid me to play the song, right? Depending on how the transaction is structured and who benefits from it. So in the case of me wanting to sell my song, I'll pay Walmart to play it, right? Well, then I haven't transferred my rights. The rights are mine. I get paid and I use an intermediary to help me sell my song. Well, in that case, the two parties are acting simultaneously, right? I haven't transferred it permanently. We're both involved in the thing. I exercise my right and Walmart's help me out. Another example is if I have a video, right, and I want my videos to be on the internet, and so I will upload them to YouTube. Well, YouTube is going to be the intermediary that's going to help me distribute and disseminate my work. And again, we're both acting simultaneously. I'm still the copyright holder, but I enlist the help of YouTube, right, to distribute my work, my videos, which are copyrightable works. And then YouTube takes a cut of the money. YouTube takes 50% of the ad revenue, gives me the other 50%. In that context in technology, the right to assign, generally, the right to transfer these rights in whole or in part is going to be important, and it is what you're referred to in the textbook as the right to authorize. The right to authorize is a right to enlist a third party like YouTube or Walmart to help me exercise my rights, to help me sell my book, publicize my book, whatever it is. But that's a variation of the right to assign, right? So what I've done in that case of YouTube, is I've assigned the right, in part, right, to play my song in public, right? So YouTube is public, right? We'll see that in greater detail later on. YouTube is public. It's a website that's accessible to everybody, kind of like a park, right? And YouTube, I tell them, well, I give you the right to play my video on your website, performance in public, but that is limited. I only let you do that, right, if you pay me half of the ad revenue. So I keep my right, I assign it in part. I either tell YouTube you get a part of my right for a limited period of time or forever, or I tell YouTube, you pay me royalties to exercise the right for me. That is an assignment. The book calls it authorization. I think that's a bit confusing because it's the same thing. The right to authorize YouTube to play my song, right, or to play my video, is me assigning the right to play the video in public, right? In whole or in part. And when it's in part, they call it authorization, but it's still an assignment. It's a partial assignment. It's an example of the broader concept that these three rights are mine, as we said, are not personal. They can be sold, assigned, transferred in whole or in part. And that's number 4, which is also called authorization. So, tons of fun. What is the life of the copyright? So we'll erase this. I'm sure you'll recall that substantiality is a trigger issue because I've told you probably more times than is necessary for university students. And we'll look at what period is covered by the rights that are provided in the Copyright Act. And you're given the general rule in sections 6 to 12 of the Act, right? Section 6 has the general rule, and that is the life of the copyright holder plus 50 years. So, what does that mean, right? I make a song. That's an example. We'll see specific categories. It actually depends if it's a song or something else. Who makes it? Say, general example, I make a song, right? Well, while I'm alive, right, I can, every time someone plays my song on the radio or on Spotify or in a public event like a wedding for commercial purposes, a concert, whatever it is, right, I am going to get paid. Because if they don't pay me, right, and payment is what? Payment is consent. Right? Consent to copying my stuff. And usually the reason people give consent is because they get money, right? So payment for playing my song is really getting my consent, and the way they do that is they give me money, right? Every time my song is played in public, that's one of my rights, or reproduced, right, I get paid. They have to have my authorization. So, how long can I exercise those rights? The answer is in section 6 of the Copyright Act, and that is my life plus 50 years. So as long as I'm alive, Spotify, the radio, YouTube, everyone is gonna pay me for playing my song, right? And then when I'm dead, they're gonna pay my estate, right? Dead me. And then whoever dead me becomes, when I assign these rights to people, right, for 50 years, these people are going to get paid. So life plus 50 years is the general rule. What does life mean? This is not what you think, so kind of a thing that might be interesting to put on an exam. It is the end of the civil year. So if I die in September, right, it's not 50 years from September, it's 50 years from December 31st of that year. December 31st plus 50 years. That's a general rule. Now, what if we have joint authors? Well, it's the last one. So as a general rule, if there's 2 of us making a song, then there's 2 of us who own the copyright. This is important, right? We're talking about joint authors, right? But we're really talking about joint copyright holders. So if I pay someone to be in my video and they get paid for it, they don't have rights in the product because I've paid them to be there. And I've paid them so they don't own the video afterwards, right? That's why we pay actors, for instance. Actors get paid to be in a movie. They don't get 2% of the profit forever. They get paid once. They get paid not to have rights in the product that is ultimately sold. So, in that case, joint copyright holders is clearer. So 2 of us make the song and own the song. So someone made the song with me, not someone I've paid to be in it, but someone who creatively made the song with me, owns the song? Well, then there's two of us who own the copyright. And so if a radio plays the song, well, they pay who? The copyright holders, and that's me and whoever made the song with me. In that case, it's when the last author dies. And so I can die, the copyright goes on, and then without, the clock ticking yet, and then when my co-author, co-holder dies, well, then it is end of the civil year plus 50 years. So if they die in April, it's December 31st of that year, and then from then, the 50 years starts ticking. So we have, we also have some different situations that are illustrated. What if it's a company, right? So again, a company is a good example of what I just said. A company is like an actor, right? Let's say I'm a copywriter, what they call a copywriter. I'm someone who writes text, right? So if you go on a website, right, let's say someone has a bakery and then they have a website. Usually they'll have pages full of text, and the reason for that, right, is so they can show up in Google so people can go on their website and buy their bread. If I'm the person writing down what's on the website, right? So the baker hires me as a copywriter to write the pages of text, right? Well, then they're paying me. And so it's not like me writing down a book and it's mine. I'm writing down a website for my employer and I'm getting paid for it. So as a general rule, what am I getting paid for? I am getting paid for assigning the copyright to my work. And so I'm getting paid to write stuff that doesn't belong to me. I'm getting paid to write stuff that belongs to my employer, and my employer can do whatever they want with it, right? That usually arises out of the very fact that I get paid, but usually it's also specified in employment contracts that say, well, all of the intellectual property, right, your work product, while you're working for us is automatically assigned to us, and we don't owe you compensation for it. What that also means is I don't have a right to be identified as the author. So I don't have a right for the baker to put on the website, this page was written by Phil, as I would on the cover of my book, because I've assigned my intellectual property and it's mine, and I don't have a right to claim authorship because I've assigned my intellectual property. And so what if it is a company? Well, company doesn't have a life plus 50 years, right? A company is a person that lives forever. So a company, usually, let's say they have a team of 3 people that produced a work, right? They're not the holders, the company is. Again, this is important. The company holds the right, but the life that is used for the rule has to be the life of a human. And so we have a legal fiction that operates here, and that says, well, even though the joint authors are not authors, they're not copyright holders, the company is the owner, holder of the copyright, will determine the duration of the right of the company with the life of the employees, even though the employees don't own it. And what is it going to be? Same rule as above, last author plus 50 years. And so if we have a team of 3, again, the first 2 can die, the clock doesn't tick. When the last one dies, at the end of that year, the 50 years start ticking, right? That is from, again, not the date they die, but from December 31st of that year. So it wouldn't be a rule if it didn't have exceptions, right? The exception, again, the crown is the government, right? The federal government. Well, doesn't have a life, right? Like a company, but it's not a company, so we will not use the life of the people who created the work, right? There's a separate rule for that. So the life of the people who created the work for the government, doesn't matter. It's just 50 years from the date the work is published, right? So there's two things. It's either 50 from publication, right? So from the date the work is published. Again, if it's published in June, year means December 31st, sorry. So from the end of that year plus 50 years. If it's published in April, December 31st that year plus 50 years. But if it's unpublished, it's forever, because the rule doesn't apply. So it's not 50 years from the date it was written, it's not 50 years at all. And so the copyright is not limited in time until the work is published. If the work is published, 50 years from December 31st of the year it's published. Until it's published, it's forever. The copyright subsists forever, and when it's published, if it's published, starts running. So there's a similar exception, right, that is different for, we'll call this film, but. So it's a film, but, right? And what is that? It's for what they call cinematographic works that do not have a dramatic character. What does that mean? Well, it means a video that is not a movie, essentially. If it's a movie, like you'd see in a movie theater, then it has dramatic character. If it's you filming someone, then it doesn't have dramatic character. And what is the rule there? Again, we have this distinction for the Crown between published and unpublished, but the rules are different. If it's published, it is 50 years from the date it is first published. So again, December 31st of that year plus 50 years. If it's unpublished, it's 50 years from the date it was made. So December 31st of the date it was made plus 50 years. There's a distinction there, right? Same rule for published works as the Crown, but for unpublished works, unlike the Crown, it doesn't subsist forever. It subsists for 50 years from the date it was made. And what that also means, tangentially, is that you can extend the life of the work, right? Because once I make the movie, the film, the non-movie film, non-movie video, then we don't know if I publish it. And so the 50 years starts running from December 31st of that year. Once I publish it, I fall under the other category, starts running again. And so I extend the period because I fall under the first rule, because you don't know if it's gonna be published until it's published. So by default, the first period runs until you become subject to the first one. So we'll erase this, and we'll get back to the rights of the copyright holders. That was the period of time, right, for which the copyright holder has those rights. And now we'll look at those specific rights that we enumerated below. And we'll do the first one in this section, and in the following sections, we'll do the other one. So we said there's the right to produce or reproduce, the right to perform in public, the right to publish, and the right to assign, which is really, an intrinsic character of the three rights being transferable, in whole or in part, for money or not, right? So the first right to reproduction. We'll look at this in this capsule, and we'll also look at it in the next one, and then we'll look at the other three. So the right to reproduction. Again, I'll repeat it again. This is for the work or any substantial part thereof, because we have substantiality as a trigger issue on all of these rights. And so it's only copying if it's the work or a substantial part thereof, right? And again, we have this this idea that I told you about before, right? That you don't have to copy the thing verbatim. And so if you take, the thrust of the book, if you copy the book, everything that's in the book, but not literally, if it's a substantial part of it, it's copying, even though it's not the exact thing. But again, it's not copying because it's an idea, because ideas are not protected under the regime. You're not copying the ideas, you're copying the work. And so the reason that you're copying counts is not because it's an idea. It's despite of the fact that it's an idea. It's because it is a substantial part of the work. So then we have obviously some interesting issues as to, of course, what it means to copy, right? And we have some similar issues in, for instance, the criminal law, right? What does it mean to possess child pornography? Well, if I have a DVD in my house, I am in possession of child pornography, right? What if it's on a computer? Well, it's kind of harder, right? If you download it, well, that's possession. It's kind of like having something in your living room, but it's on your computer, right? What if it's a link? Well, then, not clear whether you possess it. Does saving the link count as possession? Hard to tell. And we have these similar issues beyond the criminal law in the intellectual property context, and especially so with the use of technology. What does it mean to make a copy? Accessing a website doesn't make a copy of it, right? What if I save it? What if I download it? And where along that continuum does it start to count? There's no definite answer for that, but we'll look at examples that are helpful. The first case that we have again is the infamous Tiberge case, which we looked at before from the Supreme Court. And in that case, you have in your textbook both the dissenting decision and the majority decision. And so we're going to look at both and contrast both. It's fine if you didn't notice that. It might have made the case a bit more confusing to read. But we'll look at those. And the second one is the majority, and it's the correct statement of the law as of now. So in the Tiberge case, what do we have? Essentially, I'm simplifying the facts here, but let's say we have a canvas. And so I have this nice, call it a painting, right? A poster, whatever it is, of something, and that's an artistic work, right? And what I do with it, I essentially transfer it onto something else. So I make a kind of a copy of it, right? Whether or not it's a copy is going to be the trigger issue here, but I make a copy of it, right? But that destroys the first one. And so I don't really make a copy of it in the sense of having two, of copying it literally. I really transfer the ink from the first one onto the second one. So from one piece of something onto another piece of something, and then the first one no longer exists. I only have the piece of paper because I transferred the ink. And so we start with one, right? As the majority said, and we end with one as well. So what does the dissenting opinion of Justice Gontier say? Well, they say that it is copying, essentially. That's the answer, right? So we have the dissent, right? The judges that are not in the majority, and they say, yes, it is copying. And then we have the majority with Justice Leroux-Dubé that says, no, it is not copying, right? So what does the dissenting opinion say? Well, they say there is no distinction, right, between producing a work and reproducing a work. That's what they say. I'm not sure if it's true, but as I said, it's the same right? We have an exclusive right as a copyright holder to produce or reproduce the work. So to make an original copy of it or a duplicate of it on any medium, right? So I can, make a copy. I can scan a document. I'm starting from a piece of paper and I end up with an electronic copy. This different medium, it's reproduction. So they say there's no distinction between production and reproduction. And so for a right to exist in a copyright, it has to be fixated. And we discussed this last week, right? We said there isn't an explicit fixation requirement in the Copyright Act. In fact, there's only a specific requirement for certain types of work. But as we said, right, to turn an idea into a product that is copyrightable, because ideas are not protected by copyright, you have to put it down onto a medium, whether it's electronic, paper, whatever else. And that is fixation, whether you call it that or not. Justice Gontier says, well, a work has to be fixated. And what did they do here? Well, he says it doesn't matter that you had one and ended up with one, right? What you did is you took the ink and fixated it onto something else. That's fixation. It's the trigger issue. And so it's reproduction in the same way that it's production, right? In the same way that fixation gave rise to the initial work that was copyrightable, right? Fixation of the copy made it a copy, and that's it. That's what the minority decision says. Then Justice Binney, for the majority, I think I mistakenly said Le Hudspeth earlier, or do we have, I think we have both, but regardless, the beginning is from Justice Gontier. So Justice Gontier says it is not a copy, right? And how does the majority say this, right? They say that they go back to the broader issues that define copyright law. And it's good to know, right? As we said, copyright law, like all of intellectual property law, right, is underlain by policy consideration. Because what we're doing is we're giving someone a commercial monopoly that they wouldn't otherwise have. And so we create a law, we create a thing that says you have a monopoly. There should be good reason for that. And the good reason should be in the public interest, right? And the good reason should serve as the interpretive aid of the rights we give you. And so when we ask what the law says, we think about what the purpose is, what the policy considerations are, right? That helps us interpret it, and therefore it also limits the rights, right? We may interpret it more limitatively because we're guided by the underlying policy consideration. And what are those? Well, we mentioned them a bunch of times last week, and that is to balance the right of the copyright holder, and that's a public interest in making sure that people who produce works make just compensation from them, derive economic benefits, right? And that's public because it is fair, but most importantly because it ensures that people are incentivized to produce these works in the first place, right? And that is a right of the copyright holder. In opposition to that, we have the right of the public to access stuff. And so if I give too many rights to the copyright holder, to the person who makes the book, then they can prevent everybody else from reading the book by not selling it. Or if I give them the right to control how the book is used after it's sold, the right to integrity, for instance, well, that limits the ways in which the reader can use the book, right, for fun, to use it, period, and to use it to come up with their own thing. And there's a public interest in the dissemination of ideas in itself, and so that ideas can spark further ideas and innovation, right? And we have this opposition, this tension as we pick a compromise in the law in achieving a good balance between between the rights of the copyright holder to just compensation and to incentivize them, and the right of the public to access works more easily and more freely. And of course, what does the majority say? They say, well, the dissenting group is wrong because they screw up the compromise. They give too many rights to the copyright holders, right? Because what does that mean in that case? It means the person that bought the painting or the poster, call it whatever you want, the person who bought the poster, right, cannot transfer it onto something else, even if they don't have a second version of it, because then they have not just changed the nature of it, they've done a reproduction, and that's forbidden unless it's allowed in their contract, but by default it's forbidden, right? And so that person has only one version at the end of it, but they have infringed the rights of the copyright holders because they have reproduced the work, right? When I bought the painting, the right I was given was to own the work, right? It was to have the painting put in my living room. It wasn't to make 5 copies of it and sell them. It's different. It's commercial interest, right? Well, in that case, to transfer that for the dissenting decision would be copyright infringement because it would be reproduction in violation of the rights of the copyright holder, the person who made the painting, whose rights would extend after it is sold, right? And what does the majority say? They say, well, that is wrong, right? That is too restrictive. First, it's kind of weird and intrusive. The copyright holder can come in and decide what you do with it when you're not really copying it, right? That's what they say. Then they say it's not a copy, right? Because you're transferring it. You're kind of renovating it, right? Like you would an old painting to ensure that it lasts longer, right? You're renovating it. You're not copying it. So it's not reproduction. It's not a violation of the rights of the copyright holder. And what else does the majority say on the policy question? The majority says that gives too much to the copyright holder, right? The copyright holder has the right to reproduce, but now you're saying that that's not just making copies illegally, right? When it's not allowed under my contract when I bought it. You're saying that also prevents me from putting it on a different medium and having only one copy. That is an expansion, right? It's not a new right, importantly, but it's an interpretation of the right to reproduce that enlarges it. And what the majority says, that gives too much to the copyright holder, right? And it upsets the balance between the rights of the copyright holder and the right of the public to freely access the work. In that case, it's the right of the person who bought the painting to do whatever they want to do with it, as long as they're not making illegal copies of it, to use it, and to exercise their right when they bought it to use it, right? That's essentially what the majority says. And how do they justify that interpretation? They say, well, we get back to this balance we're trying to exercise between the two competing interests. And we're right because it's a rhetorical argument, right? Because courts, they don't just state things, right? They argue. They try to say why they're right. And the reason the court says it's right, the majority says it's right, is because it ensures the balance between the two competing interests, which we've looked at throughout copyright law, and which we'll see throughout intellectual property law, right? And it's going to be the same for, say, a patent. A patent is I invent something, right? You have to note this down. It's an example. We'll look at it in greater detail. Let's say I invent a snowmobile, right? Well, I'm just a guy that invented my snowmobile. Well, what if I start selling it? What's going to happen? Well, some big company is going to copy it, right? I've invented it. So they don't know it exists yet. But once I sell it, they'll buy it, they'll take it apart, right? They'll make their own, and they'll sell it. And even though I've invented it, they'll make it faster, cheaper, better, because they're a big company, and then they'll make the money and I won't, right? And so what am I going to do? I'm going to keep it to myself. I'm not going to tell the world that I've invented this great thing because I'm worried someone's going to steal it from me. So again, we have this interest, right? We have an interest in making sure that I get paid for my invention, that a big company doesn't steal it, right? How do we do that? We give me a monopoly, right? We say, I'll give you a patent, which is an exclusive right to sell the thing. And so the big company can't take it from me for, say, 20 years, right? They can't steal it, at least for a period of time. I have a monopoly, right? So that's my interest in making money from my inventions. And there's an interest of the public in having access to my invention. Because as we said, if I'm worried someone's going to steal it from me, I'm going to keep it to myself. And that's bad because there's a public interest in making sure that things get invented because that drives society forward, whether it's new drugs, new machines, whatever it is, right? And so the policy considerations are always important in the law of intellectual property because they justify stuff that doesn't exist elsewhere, right? It's the bull in the china shop, right? You're giving someone a monopoly. You know, a monopoly in the real world, right? That's called antitrust law. And what antitrust law says is a monopoly is illegal. If I buy all my competitors, that's illegal. Why is that illegal? Because I can jack up the price and make money, and that's abuse of customers, and that's bad. It's the opposite of capitalism, right? At least on paper. Capitalism is, you know, there's all these people competing with me that makes me better, cheaper, and that's good for the end customers, right? And so monopolies are illegal under antitrust law. What do we do in the law of intellectual property? We do the exact opposite, right? The government doesn't crack down on the monopoly. The government gives you a monopoly, right? You don't have a monopoly until the government says you're the only one that can sell your book. They can copy your book, sell copies of it, or the only one that can use your invention, sell your invention, make money from it. The government creates a monopoly. That's a massive nuclear bomb on the system, right? It's a violation of fundamental principles of competition and economics, right? And it's the government that does it. And so there has to be a really good reason. And a really good reason is what we've discussed so far and what we'll see in the law of patents, the law of copyright, the law of intellectual property more generally, because it often is a state-sanctioned statutory monopoly that has to be justified with good reason. And so the good reason acts as an interpretive aid to the monopoly, to the extent of the monopoly, and limits it, right? As a restrictive interpretive aid to the monopoly as well. And so that is essentially what the majority says. And the majority says, you know, the painting wasn't copied because it wasn't copied, because you started with one, you got one, you really just renovated it, transferred the ink, you didn't make a copy of it. And importantly, at the end of it, the court emphasizes, you know, the distinctions that I've tried to hammer home since the beginning of the course, right? The court says that does not mean, right, that we are restricting what a copy means. What we're saying is this is not a copy because you don't have a copy. And the court says that doesn't mean that the right to reproduce is necessarily limited. We're just saying it doesn't apply because it's not a reproduction. And so it's still true, right, that you can copy for different reasons, intentionally or not. You can copy parts of it. You can copy the important characters of a book, for instance. That's a substantial part thereof. And it doesn't change the fact that you can copy onto a different medium, right? That you can take a paper copy and then with your scanner make an electronic copy. Does not change that, and the court mentions that. And the court also says, right, and if you don't understand what I'm about to say, just forget it, it's not that important. But the court says we're back to the distinction with moral rights that we've just discussed before. This part of the regime is not about moral rights. It's about economic rights, and the distinction is important, and it's been important since the beginning of the course, right? We're not concerned with moral rights. And so this is about protecting your right to make money with your stuff, not your right to the integrity of your stuff, right? Not putting toilet paper on my statue, right? We said that before. That's different. That's not relevant, different regime, more restrictive. I think I've said it enough times for me not to have to repeat it. But that's under Section 28 of the Copyright Act. And Section 28 of the Copyright Act does protect your right to integrity, but only some of the times, but only when it's prejudicial to your honor or reputation, right? And what does the majority say? Well, the majority says this is not a copy, right? That's their frame of mind. We have to accept that first to understand the argument, right? Because the dissent doesn't agree with that. They say it is a copy, so it doesn't matter. The court says, the majority says it's not a copy. Well, if it's not a copy, what is it? It's a modification. I'm pimping, right, the painting. And what does it mean to pimp the painting, right? It means to alter it, right? And what does the court say? Well, if you're pimping it instead of copying it, that's not copyright. It's not copying, it's your moral right. And so you're trying to put into the law of copyright the moral right, right? If we accept that it's not a copy, what you're saying is the author has a right to make sure, not that you don't make a copy, because they have that right here. It's written, it's economic, we're good. You're saying the author has a right to prevent you from pimping it. And as we said, that is the opposite of what the law of copyright says. Once I have paid for a song, right? Once I've compensated the copyright holder for the right to own the song, to play the song in public or not, depending on what I've paid for, and I can do whatever I want with it. I can play it as many times as I want. I can play half of it. I can cut it in half. I can mutilate it, right? It's not under this regime. The court says, well, if you're preventing pimping of the painting, you're giving the painter, right, a right after they have sold the painting to ensure that it's not modified. And that is not copyright. It's not any of those rights. It's a right to integrity, which is not relevant here. And the court says we can't do that here because we're under economic rights. We're not under Section 28. And if we were under Section 28 for moral rights to integrity, then we'd have a different standard, and the person, the painter, would have to come to court and say this was not only a violation of the integrity, right? It only matters if it's prejudicial to their honor. So they'd have to go to court and say, well, they have pimped my painting, and now it looks bad, and everyone knows it looks bad, and now no one will buy anything from me, and so I'm broke, and so that is damages, right? I've lost money, lost income. Reputation generally is income, right? If I don't no longer have a reputation, that prevents me from making money usually. That's damages that I can claim. And the court says we cannot try to prevent this here because we're under economic rights and not Section 28.